Okay, thank you. We are back in Vermont House Judiciary Committee after a brief break. Thank you, everybody, for your patience. It's a busy week before crossover, and so lots of people, our witnesses, are in many places at one time. So I'd like to please start with James Pepper of the State's Attorneys and Sheriffs, and if we could first look at the annual report that is in this draft committee bill, and very much appreciate you working over the break in the last few days with the sponsors of which was H.428, where this language or something like it, the intent was in there, and bringing this language forward. So good morning and welcome.
Thank you. For the record, James Pepper from the Department of State's Attorneys and Sheriffs. So when I first saw the reporting requirement, my instinct was to reach out to the courts who collect conviction data, and the crime research group, who just really has kind of a wealth of knowledge about where to find data, how to analyze it, or what's available. And so I did both of those things, and I also reached out to the Office of the Attorney General, because I thought one thing that might be missing from that report really is things that fall short of a hate crime, things that couldn't be proved beyond a reasonable doubt under the hate crime statute, but might result in a civil action, and under some of our other civil statutes. So things that are prosecuted under the Civil Rights Office at the Attorney General's office, and I am the what's called the Bias Incident Coordinator for the Department of State's Attorneys. So things that get reported as hate crimes or bias incidents, but end up not being prosecuted for one reason or another, I refer over to the Civil Rights Office to see if there's any civil actions that could be taken. So, so I took an attempt to redraft this. By the way, when I reached out to the courts, I asked for any conviction from the last 2 years that the sentence was enhanced by the hate crime statutes, which is 13 VSA 1455. And so they were able to run a report, and sure enough, there was only one conviction where the sentence was enhanced by a hate crime in the past 2 years. So that's not a very, I think, useful report, other than the fact of the kind of absence of evidence there. What Rob and Joy and the Crime Research Group were able to provide is a much more robust report that includes incidents of bias-motivated crimes that were referred to prosecutors' offices in Vermont that maybe didn't end up in a conviction, or definitely didn't end up in a conviction. That data can actually be broken out by demographic information. So that is the first section of the reporting requirement that I put together, which is incidents reported to the National Incident-Based Reporting System where there is an offender bias against sexuality or gender identity. And so that is something that the Crime Research Group can provide to the state's attorneys in a kind of consistent way. And then the second piece would be any convictions in the criminal division of the Superior Court for which the sentence was enhanced pursuant to 1455, the hate crime statutes. So you can, I think what you'll see there is where there was a bias incident, but then from in A, and then from B, you'll see, did it actually lead to a conviction? And then the last part of this would be subsection C, was that last piece that I discussed from this kind of the civil rights angle, which is bias incidents that resulted in a final judgment in the civil division. So those would be the cases that through the bias incident reporting system didn't really end up in a hate crime conviction, but were referred over to the Civil Rights Office and led to a final judgment there. So I think, and then I got on the phone yesterday with Robin, Joy, and the two lead sponsors of the bill, Representatives Cordes and Small, and walk through some of the kind of complexities of this and some of the limitations, especially when we're talking about small populations and trying to report on demographic information, particularly of victims, that it would inevitably identify the victim of these incidents, because we're talking about usually less than 5 incidences. Certainly in the case of convictions under the hate crime statutes, 1 in the last 2 years. So it's just probably would want to get consent from those victims to kind of republish the demographic information related to their case. And so I just thought, and they were in agreement that taking out the demographic information about victims and adding that language to the extent possible, or to the extent feasible, about the demographic information of the defendants would probably be a good, just a good thing to do to protect people's privacy. But that's how we came up with this language. And again, the lead sponsors are think that this is a good path forward, and also recognize that some of the other work that I was discussing about the kind of Bureau of Racial Justice Statistics and some of the other data collection initiatives that we've been looking at will add more consistency to data that's being collected and reported, and will add a lot more value to the analysis. And so they felt confident that this would be a good report, and that there's more work to be done that probably is not covered by this reporting requirement.
Great, thank you. Thank you so much. That's very helpful. Let me see, I'm not seeing any hands or questions. Oh, Selena, she's. Oh. Can't hear you, Selena.
Sorry about that. I'm just pulling up the language. I had a question on just one provision that I thought you would perhaps be the best person to answer. So it's in the reporting section.
Mm-hmm.
And it's B1A. So, I mean, I know H.428 was focused on offender bias against sexual orientation, gender identity, etc. But I think that's important information to peel out, but I'm wondering, how accessible the national incident based, all of the incidents we send to the national reporting system, like, are there other ways that information is generally accessible to us?
Unfortunately, Robin was the one that kind of helped provide this information and works closely with that. But my understanding is that there are many other categories of bias motivated coding that happens in law enforcement that could be reported here. It would not be difficult, for instance, to include race, ethnicity. If that's the direction that the committee wants to go, I don't think that would be very difficult. And honestly, if you look at sub 2, where their convictions, where the sentence was enhanced by the hate crimes, it's going to cover a lot more than just gender identity or sexuality. So in some ways, I mean, I don't want to move too far away from the original intent of this reporting section without, I mean, the committee, I didn't want to do it. The committee certainly can. But I was trying to kind of stay true to the original intent. But if that section were expanded, I don't think it would be an additional complication for the purposes of this report.
That's really helpful. And that was my thought too. Like, let's extrapolate this data, but while we're at it, we might as well ask for the whole picture of how those incidents are breaking down, unless that's really transparent and accessible in some other way already. So I really appreciate that.
Yeah, I mean, I'm currently looking at the report that Robin pulled from the NIBRS, it's called, or shorthand, NIBRS system. And, you know, she only isolated the ones that related to sexuality or gender identity. And so there's a category here of anti-gay, anti-lesbian, anti-LGBTQ, anti-heterosexual, anti-trans. So, you know, these are the different codes that law enforcement uses when they're reporting to this. So I don't think it would be difficult at all to kind of expand that list to include anything that might be considered a hate crime under 13 VSA 1455.
That's great. Yeah, I think I would advocate for us to go in that direction. Thank you.
Thank you. Coach.
Good morning. At an earlier meeting this morning.
Coach, it's hard to hear you.
Is that better?
Much better. Thank you.
Okay, great. I guess my mic was aimed down. At an earlier meeting this morning, we were talking about how this information gets disaggregated. And James spoke clearly about that as far as it becomes very specific because of our small populations here in Vermont. So depending on the direction that we go, to Selena's point, we do see that happening. My question on the front end of all of this is, what steps are being taken to ensure that the complaint is actually being referred to law enforcement? And then the question becomes, is it getting into the system, so to speak?
Coach or Representative Christie, that is a great question, and one that was flagged as a real problem with our data currently, is that the vast number of these crimes go unreported for any number of reasons. You know, it could be a mistrust of law enforcement. It could be someone's is embarrassed or ashamed or doesn't want to make this situation public. And so there are any number of reasons why this data is underreported, and that this report will not give a true picture of what is happening in people's lives.
Thank you.
Yeah, thank you. Selena.
This is a comment, not a question, but I would also say that another complicating factor to Coach's point and Attorney Peppers is that sometimes not all law enforcement equally has the skill to recognize incidents as being motivated by bias. And then that was something I saw a bunch of times in my work as a city councilor in Burlington, where I had to intervene with constituents at times because in their initial interactions with dispatch or with law enforcement, there wasn't, for whatever reason, there just wasn't an understanding or an articulation of like, oh, this person is experiencing, harassment or an assault or something, and the motivation for that is bias. So I think it's, in addition to that, the underreporting that just might happen, there's also, I think, reporting happening of incidents, and there might be really varying skills among dispatchers and law enforcement about their perception of those events and their, willingness or ability to kind of code them in these ways. So multiple layers of complication.
Yeah, thank you. Okay. Seeing any other hands? Anything else, James, at this point?
No, I mean, I was in the other committee. I'm happy to look at the ACLU's proposal, and I can try and do it in the interim, but I don't have anything else right now.
Okay, great. Well, thank you. Thank you so much. Again, I appreciate your work on this reporting section. It really is helpful, and certainly we'll move this forward, I'm sure, at least this
Great,
section of the committee bill. Okay, great. David Scherer, please, Attorney General's office.
Good morning. Thank you, Madam Chair. For the record, David Scherer with the Attorney General's office. Again, I apologize having to jump back and forth between committees like Attorney Pepper. I was not privy to all of the discussion and debate. I will say that a few things here. I'll keep my comments relatively brief just because I don't want to reiterate too much of what you might have already heard, but talk about a few issues, and then certainly happy to answer any questions that the committee might have or ask me to go more deeply into some of the issues. I'm happy to do so. The Attorney General's office supports this language. The Attorney General's office believes that it is constitutional and thinks that it could be a helpful tool to remove what a court might interpret as an additional element, an additional burden in bringing one of these enhancements, or I should say improving one of these enhancements, and it would bring Vermont in line with the majority, I think the great majority of jurisdictions that have an enhancement along these lines. So, you know, we do support it and think that it is constitutionally supportable as well. A couple specific issues I want to talk about, and I'll address a bit of the ACLU's proposal, although I haven't had a chance to review it until just about 25 minutes ago, and I've been desperately trying to read some case law while Pepper was talking about the reporting, so I'll do the best I can here, but if the committee wants to go deeper, I may need to come back on that, but I can give an initial read of it. And an initial read on a couple of the other issues that I heard being debated earlier in the discussion of this bill. So first of all, again, we don't think that the term maliciously is something, adding the term maliciously is something that is constitutionally required. In fact, we don't think that there is any constitutional basis for that. And I don't think that there's a case out there that would support that. I know there was some discussion, I think brief discussion around the Schenck case that came out in 2018. And I don't think that that is relevant to the inquiry here. Schenck was really talking about what types of behavior can be criminalized under the disorderly conduct statute, and basically held that under a certain provision of the disorderly conduct, only physical conduct can be held to be criminal, not basically it said that no speech could be held to be criminal under that provision. So that was really talking about what may be criminalized. It's important to remember that what we're talking about here, by definition, everything that we're talking about is a crime because this is an enhancement for a crime. So we're not talking about what behavior may be criminalized or not. We're talking about only criminal behavior. All we're saying is, how can you sentence that once a crime has been found? Criminal behavior is not protected by the First Amendment. And any time that somebody has been, and if there is an argument about whether something may be criminalized consistent with the First Amendment, that argument will happen pursuant to the underlying crime. For example, going back to Schenck, if there's an argument about whether the disorderly conduct statute can criminalize certain types of expressive conduct, that constitutional argument will be happening pursuant to the criminal provision. But this provision only comes into play when a crime has already been established, there isn't a constitutional issue with that crime, and the crime's been proven. Now we're just talking about how somebody can be sentenced, which again, sort of by itself is a significant constitutional protection, because we're only talking about behavior that is not protected by the First Amendment. We're talking about criminal behavior here. And as the committee has also heard, I believe, there's been some discussion of the key Supreme Court case on this issue, the Wisconsin versus Mitchell case, which does allow for the US Supreme Court did hold that enhancing penalties on the basis of biased motivation is permissible. The ACLU's provision, as I understand it, is essentially trying to bring this proposal very precisely in line with the statute that was at issue in the Wisconsin case. And I think it would potentially narrow some of the applications that this could be used for. My initial read of this, and again, I may have to come back after having done a little bit more research on the various circuit cases that apply, but my initial read of this is that the reasoning of the Wisconsin case is not so precisely limited to the language of the statute that was at issue in the Wisconsin case. The reasoning of it was that, hey, we're talking about unprotected behavior. We're talking about crimes, not protected behavior under the First Amendment. And it is permissible for a state to say that motivations that lead to that offense can be considered in sentencing. And they used other analogous cases to support that. But it did not base its reasoning on the solely on the act of victim selection. Its reasoning was really saying that motivations that the state motivations for an offense, for what is constitutionally unprotected behavior, a criminal offense, motivations for that can be taken into account when a court is deciding how severe a sentence should be. And motivations that the criminal expression, motivations that result in a criminal expression are, as the court noted, especially harmful to society. And it is reasonable for the court to sentence those more severely. And I don't read the victim selection aspect, the fact that it was a victim selection phrasing in the Wisconsin statute as limiting the court's decision and reasoning solely to the act of victim selection. I believe the court's reasoning supports the slightly broader notion that bias motivated action it is permissible to have a sentence enhancement for that. So again, that's my initial read. I would need a little bit more time, I think, to give you a more comprehensive view of where the circuit courts around the United States have landed on issues like that. And I was in the middle of trying to skim a bunch really quickly, but I couldn't say that I was able to complete that process by any means in the last few minutes. So that's an initial response. We do support the bill. We think it is constitutional and as it is written and introduced. And I think we appreciate the work that State's Attorney Pepper did on the reporting requirements and think that that is a reasonable way to proceed. And happy to continue discussions on implementing that.
Great, thank you. Thank you very much, David. And I realize I'm putting you on the spot, so appreciate you doing what you can in a short time. Coach.
Thanks for doing the yo-yo thing today, David. It's that time of year. The point that you made about Attorney Pepper's work on the data section. As part of that collection piece, I know that your civil rights division had implemented a bias reporting system. So is that going to be that point of information or that, that data from the AG's section?
Yes, we'll certainly have to be involved in helping to put this together and make sure that everything's being captured, especially that subdivision B convictions, or sorry, subdivision C, reported bias incidents that resulted in a final judgment in the civil division. Will certainly be involved in making sure that those are cataloged.
Right. So just a quick question right now. Do you have a reference to the categorization, of the reports that are coming to you?
That would really, yeah, I mean, it's a very good question. I know others have been thinking about that as well. And I think what you're getting at is how do we define what falls within this category of bias motivated incidents? And I think Representative Coburn raised a good point as well, that there are various levels of understanding around what may fall into this category and what may not, and there needs to be some consistency on that. That's something that our civil rights unit is very aware of, and those questions are not simple to answer. I think that the way this is written, it's very clear, and I think the reporting is very doable. So that's a good thing. I think that we all need to do more work in making sure that there is a common understanding and a common reporting practice for all of these incidents across the board, including ones that don't result in a final judgment in a court. So that's work that's ongoing. And I know Julio Thompson, our head of our civil rights unit, has been engaged in law enforcement training on this. He's actually been doing that for years. And I think that we all understand that's something we need to continue on and really hope we gain that sort of common understanding and reporting practice around what constitutes an incident like this and how do we make sure it's being reported consistently across the state.
Great. Thanks, Dave.
Great. Okay. Giving folks a chance to raise their hands or unmute themselves. I'm not seeing anybody. Okay, thank you. Thank you so much, David.
Thank you.
Thanks. I would now like to turn to Rebecca Turner if you are available to speak to the reporting language, please.
Good morning, everyone, and thank you. I will focus testimony on that. For the record, Rebecca Turner from the Office of the Defender General, although I'd also like an opportunity to respond to the ACLU's suggestion. And maybe let me go there first. And that was about replacing language that tracks more closely to that Wisconsin v. Mitchell. And I heard Bryn's suggestion as well as to whether or not adding criminal to conduct was enough. And then of course the others. My response to all of it is that even the ACLU's proposed language doesn't fix the First Amendment problem, that while appreciating everyone's attempt to make sure it complies with Wisconsin v. Mitchell, looking at that decision, it's complicated, but not that complicated. It's the statute at issue is absolutely different from the statute here. Even taking the language that ACLU is proposing doesn't get close enough. Just getting to an intent requirement doesn't save the statute. And I know the time is short here and I can go further into it if you want to discuss that in more detail, because it is absolutely, it's a complicated area of law. And just because David Scher suggested that just because crimes may be limited to protecting unprotected categories of speech from the First Amendment, that somehow gives sentencing statute, enhancement statutes, the green light to selectively punish higher based on thoughts within that unprotected category. We actually have a US Supreme Court decision saying, no, that is not possible. You still have to be within First Amendment bounds there. So it's not a free rein to just punish these particular thoughts. So I just want to leave that there. turning to the data.
Could I just interject before you move on?
Sure.
I'm sorry. Could you tell me what Supreme Court case you?
Sure.
Yep. And we'll pull that up while we're talking. Let me share that with you later, Representative Law, not just to hold it up. And it's funny because this is, of course, a case that's always there, but not this morning. The data points, I think overall comments is, it strikes me as extraordinarily one-sided, strangely selective, although hearing the comments here, there's some indication that it would be broader than just merely collecting bias against sexuality or gender identity. Certainly the hate motivated crimes captures a wide variety, and that should certainly be attempted. On the one-sidedness, the focus here on page 2, line 11, 12, demographic information, just being collected on the part of the defendant, not of the complainant, not of law enforcement, police officers, prosecutors involved. I think that is a failure and a missed opportunity. If you're going to collect data, you should get the full picture. I think questions from committee members this morning have raised that point, which is how do we make sure that we get to the issue of underreporting, or even if there's reporting, what happens next and why doesn't something happen? You don't get that by just getting demographic data from the defendant. The other point of concern upon initial read was the vagueness of the terms used, bias. I understand that Pepper is referring to commonly understood reporting, incident reports. I'm certainly not familiar with them in the civil division. I don't know what bias means to get those kind of reports triggered. There should be some link somewhere identifying what that standard is understood to be. And I think just looking through my notes, that's what I have here. And let me find that decision, Representative Lalonde, and I will share that with you shortly.
Thank you.
Thank you.
Great.
Oh, I have it. Oh, I just found it. Okay, it's RAVV City of St. Paul, Minnesota.
And what's the citation? If you can
505 US 377 1992.
Thank you.
Mhm. I don't have any more comments on this bill. Happy to come back if there are more questions for me.
Great. Actually, I do see, so Martin, is your hand up from before, or do you have a follow-up?
I had a follow-up, but the question's more for, I think, probably Pepper, and I'm just wondering about whether the demographic information of the parties is something that is available as opposed to just the defendant. And wouldn't we want the demographic information of the well, it's not really a plaintiff. This is I know it's a criminal, but of the individual who has had the crime against them because of their race or other factor. Right, so, but the question really is, I mean, is that information that's available, that broader demographic information, not just the defendants?
I believe it is available. So we could do it. Robin Joy had some real strong reasons why, if there's fewer than 5 cases, she doesn't like to release any demographic information, particularly about victims, because it would just immediately identify and publicize the case. So she had some real discomfort with the language around identifying victims' demographic information. I mean, it's a policy choice for you all. It is available. And maybe you,
So the question is, I mean, is that public information already? And it's just a matter of not highlighting it as much?
I think the kind of amplification of it by putting it in a report. And she also, I can't quite remember, but she had some information also about how that data is collected. I think it's, I forget, that kind of masks some of the actual information, whether it's officer observed or self-reported. I forget what she said, how it's collected, that actually it won't, but I don't want to speak for her. I mean, we spoke about this at length with the two sponsors, the lead sponsors yesterday, and they agreed with her that it wouldn't be helpful to include the demographic information of the victims, but maybe you could hear from her on that.
Thanks.
Thank you. Selena.
Yes, thank you. I'm just once again calling up the language. I think I heard you say in the reporting section in subsection B1B that there was utility in expanding the reporting requirements beyond convictions. Which I agree with conceptually, and I think when we were working on the previous, a similar provision in the previous bill, we got a lot of feedback that it was really hard to trace things that were not, that didn't make it to the final stage of conviction. I'm just wondering if you or any other of the, not to keep retreading this issue, but if you or any of the other witnesses want to comment on, how we could get the fuller picture beyond convictions in terms of reporting requirements.
Well, I think I'm just going to call it the NIBRS, the National Incident-Based Reporting System, which is just referred to as NIBRS. That will capture incidences where police have created a report. And so that's what that data is. It's the reporting data where they've identified a bias motivation. And there's a number of different categories of the type of bias. And so they've generated a report. Presumably that report has been referred to the state's attorney. So to me, that really is the kind of incident number. And then when you compare that to the convictions, you can see just a huge drop off between the number of bias incidents and the number of convictions under the hate crime statute. And then I think the third piece of that would be to look at convictions or judgments in the civil division, because when we get a bias incident report, we then refer it over to the civil rights office. So I think that there's kind of the three prongs to this, and they paint an incomplete picture. I think it's the kind of the data that we are able to get and report back. And again, I'm happy. I just emailed Robin to ask her for a meeting to talk about whether or not we could expand that subsection 1 of the reporting requirement.
Great, thank you for that. And I guess I'd love to hear any response from Attorney Turner as well, since I think I understood her to be raising some of these questions, if there might still be some missing pieces in the data collection picture here, and if there's any further data streams or concrete questions about how to round out that picture.
Thank you. Yes, I do. How to round out that picture, I would almost point to sort of the exhaustive work that the RDAP did and proposing a data collection that went towards, and again, building the full picture and context behind understanding why certain things are moving or not moving. And so I think that that's where you can draw upon what kind of data should be collected. And so having just gone through that exercise, I just look at this and proposal as just being incomplete and dangerously incomplete, particularly when we're trying to understand, I think, not just the number of reports, but why this is happening is what I'm presuming is the motivation here. Why this is happening? Why are the numbers the way they are? Is it an underreporting? Who's going on? How can we understand that by just knowing the demographics of the defendant? I think I understand even including the complainant information would be useful, but even more useful would be law enforcement who's involved there. Again, law enforcement being not just the police, but the prosecutors, understanding the demographics there. Whenever we get bias issues, it is useful to know the background of all the key players, and it's not just the defendant in this case.
Great. Thank you, Rebecca. Okay, anybody else? No. Okay. All right, so I'd like to take a pause on this for now and think about it, and we'll come back to committee discussion. But let's take a break, and then we have H87, and we should have a new draft, I think, so we can look at that. So why don't we come back at around 10 of 11? Okay, great.